Today, we will revisit the process of moving an existing business from one state to a new state and explain why foreign entity qualification, sometimes also referred to as foreign entity registration, is usually the wrong way to go about this. My name is Chad Cummings, and I am an attorney and a certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the law firm Cummings and Cummings Law. I also teach business law at the university level, and I hold 4 degrees, including 2 law degrees, and a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my law practice. Our firm website is www.cummings.law. Business owners often mistakenly believe that registering or qualifying as a so-called foreign entity is a fast and harmless way to move an existing business to a new state. It is not. In fact, qualifying your out-of-state limited liability company or corporation as a foreign entity is usually the worst possible method to relocate a business. It is a bureaucratic half measure that keeps you tethered to a state you no longer intend to operate in while piling on duplicate fees, tax filings, compliance obligations, and long-term legal risk. Redomestication is almost always the correct strategy instead, and foreign qualification is almost always a wasteful, short-sighted mistake in this context. Foreign qualification does not sever ties with your original state. Rather, it cements them. You are still legally domiciled in the state where you first formed your company. That means you are still subject to ongoing annual reporting requirements, franchise taxes, and other obligations in that former state. If your original jurisdiction imposes an entity level tax, such as California's $800 annual filing fee, you will continue to owe those fees indefinitely. Meanwhile, you will also be required to comply with the registration and reporting requirements of the new state, effectively paying for the privilege of running the same business twice. It just doesn't make sense. Foreign entity registration creates a double burden: 2 annual reports, 2 sets of state fees, and 2 layers of bureaucracy. If you hire a registered agent, you now need one in each state. If you update your address or ownership information on file in the public records, you must file in both places. If you want to change your business name, you are stuck with 2 sets of filings and additional approval hurdles. This is not a one-time inconvenience. It is a permanent and ongoing administrative burden that grows more expensive and tedious with each passing year. On the other hand, redomestication eliminates this duplication by legally and permanently moving your existing company to a new state and terminating your ongoing obligations in the former state. Foreign qualification means your business remains governed by the laws of its original state. If that original state recognizes expansive veil-piercing doctrines, restricts indemnification rights, or imposes stricter fiduciary duties on officers, directors, and owners, those rules will continue to apply to you even after you move to your new state. Your business is still subject to service of process and lawsuits in that former state. Regulatory agencies may continue to conduct audits, issue fines, or demand filings, even if you no longer have a physical presence there. If you want your new state to govern your operations, you must redomesticate. Foreign registration does not sever the legal umbilical cord, so to speak. Vendors, clients, and banks in your new state do not like working with foreign registered entities. It sends the signal that your business is not truly based in the state, and it creates legal ambiguity around jurisdiction and enforceability of contracts. Banks are especially cautious. They may demand additional documentation, reject business account applications, or treat you as an out-of-state borrower subject to higher and stricter underwriting standards. Licensing boards may delay or deny applications for professional licenses. Even customers may question your legitimacy when your Secretary of State registration shows you as a foreign registrant. Redomestication, on the other hand, eliminates these issues by converting your company in your new state in both name and substance. Foreign qualification also creates a trap for the unwary. Even though you are operating in your new state, your business is still tied to its former state that may have apportionment rules, filing obligations, or gross receipt taxes. Your CPA must now track income across state lines, allocate revenue using complex multi-state allocation and apportionment formulas, and prepare tax filings for both jurisdictions. Worse, many business owners fail to notify the Federal Internal Revenue Service that their principal place of business has changed, which creates address mismatches, delayed notices, and complications with federal tax filings. With redomestication, in contrast, your entire company identity, including your existing federal employer identification number, tax status, credit history, contracts, and reporting obligations, will move to your new state in a unified, coherent transaction. Foreign registration does not protect you from litigation risk. If your company is sued in the former state, you will be hauled into court there, even if you have no business activity in that former state. If you miss a filing deadline or fail to maintain a registered agent, you may forfeit your entity's legal standing or even incur a default judgment and a lawsuit. Some states even penalize foreign qualified entities with backdated taxes or fees if they determined you failed to cancel your operations properly. In contrast with redomestication, you can formally convert your entity out of the former state and terminate all lingering exposure in many cases. The biggest myth about foreign entity registration or foreign entity qualification is that it quote unquote moves your business. It does not. It merely allows you to operate in the new state as a guest while the legal home of your business remains elsewhere. Your contracts, bylaws, operating agreement, and even your company's name are still governed by the laws of the former state. If you are no longer transacting business there, this simply makes no sense. Redomestication, by contrast, allows you to move the legal home of your company to a new state once and for all. It is a one-time transaction that ends your legal and financial ties to the old state and brings your company fully under the protection of the laws of your new state. Most business owners who begin with a foreign entity registration or qualification ultimately regret it. They later realize that continuing to file in two states, pay duplicate fees, and complying with inconsistent laws is simply unsustainable and undesirable. At that point, they must redomesticate anyway, but now the process has been made more complex, expensive, and time-consuming because all previous filings must be reconciled by the attorney preparing the redomestication legal instrumentation. Legal instruments must account for the dual recognition status, and in some cases, businesses must first dissolve or withdraw the foreign registration before converting, which introduces substantial undesirable additional steps and risk exposure. If redomestication is the ultimate destination, it simply makes no sense to take a detour through foreign qualification. Redomestication legally moves your business to a new state, retaining your federal employer identification number, company name in most cases, credit history, contracts, vendor relationships, customer relationships, licenses, and banking relationships. It removes your company from the jurisdiction of the former state, and it ensures that the law of your new state governs your business. It eliminates duplicate filings and unnecessary fees. And most importantly, it provides legal certainty that your business is now domiciled in your new state with all of the rights, protections, and tax advantages that come with it. If your company has permanently relocated, redomestication is not just better than foreign registration, it is really the only logical choice. In conclusion, foreign qualification is only a half solution that creates twice the risk. Registering as a foreign entity in your new state may seem like a quick fix, but it traps your business in a purgatory of dual compliance, unnecessary cost, and ongoing risk exposure. You remain bound to the laws of your old state, taxed in two places, and vulnerable to lawsuits and audits from a jurisdiction you thought you had left behind. Meanwhile, you send mixed signals to regulators, clients, and financial institutions in your new state. Redomestication, on the other hand, eliminates all of this headache. Redomestication is a clean, final, and comprehensive solution. Do not pay to maintain a ghost of your business in its former state. Move it completely and move it correctly with the help of an attorney and CPA licensed in your new state. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this presentation is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier videos, please visit my firm website at www.cummings.law to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.